Hello, Lagos. Hello, Nigeria. And to you all listening from around the world, a big ups to you. How y'all doing? It's a great time to be in the studio, and I'm super excited to connect with you guys once again. I'm excited because the show is the Business Law Show. We're bringing it back, back and better for your, listening pleasure and of course education. With me on the show today is, I call them a friend of the house because they've been here before, and I'm happy that they are here again. I have with me Tomiwa and Dapo in the studio.
Thanks for having us.
You're welcome. Okay, and today they're going to be talking about the impact of the labor law in the typical Nigerian workplace. Yeah, so that's a very, serious, and it's a topic I think we need to be talking about, at a time like this. Yeah. So how are you guys doing?
Very good. Thank you very much, Karen.
It's good to have you guys here again.
The pleasure is ours.
Although you guys didn't ask after me since that time. Okay, so let's talk about the impact of the labor law in the typical Nigerian workplace. What's that about? Who's going first?
Okay. Well, if you're to examine the impact of the labor law in the typical Nigerian workspace, you first need to understand what labor laws guide contractual relationships between employer and employees in Nigeria. The first thing lawyers and other public speakers have noticed is that the labor law in itself is limited in scope. The labor law or the labor act, as it may be, laws of Federation of Nigeria, came into being in 1975. And if I'm correct, I don't think there has been a major alteration since it was brought into so the labor act in itself, if you peruse the content of the labor act, you will find that most of the provisions are not with the what's it called, the trend of the society.
So it's like it's outdated.
It's outdated. And we think that the lawmakers ought to have taken position to update the provisions of the Labor Act. You will find that there are still some punishment in the Labor Act that talks about 100 naira fine, 800 naira wages, which are not applicable or obtainable in this era. So if you're looking at the impact of the Labor Act generally in the Nigerian workspace, I would say that it needs to be updated. It needs to be amended to meet the changing needs of the society.
Right, at a time like this, at this time. Okay, great. So now we're saying that they need to adjust. So now they haven't done this, they haven't made this adjustment. So what is the current status of things right now? So let's look at it from that angle. Okay,
the current status of things as applicable to the Labor Act, if you are with the Labor Act, you can open up to Chapter 1, L1 of the Laws of Federation of Nigeria 2004. The major provisions in the Labor Act that still applicable to these needs, employer and employees' needs, are very, 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 very slim. It doesn't have major provisions for the changes. As I said, at least you can find the provision that talks about working hours by employer and employee. The one that talks about remuneration. You can find the one that talks about termination, how termination should be done. You see the one that talks about sick leave and all those things. We still need them to come up with so many other things. Well, fortunately, with the coming into place of the National Industrial Court, we've seen them come up with major, I won't use the word amendment, but interpretation of the Labor Act and the contract of employment between an employer and employee. So majorly, instead of focusing so much on the Labor Act, the best to do is to focus on the contract of employment that is always being signed between employers and employees. That is the most important aspect, because focusing on the Labor Act itself is limited in scope.
Yes, all encompassing.
Yeah,
okay.
Very well.
Okay, so for the purpose of this show, we're going to be looking at the contract between the employer and the employee. Okay, okay, I like that. So the law is still somewhere where we don't want to go there now because it's not in line with what we're doing. Yeah. Okay, so do you want to say something about that as well?
Anyway, I would, in my own contribution, say, we have a lot of laws in Nigeria as a country. Okay. And you look at it, the enforcement of these laws, how well do people comply? How well do people actually, even understand what these laws are? Just like what he has mentioned, anything that has to do with employment contract, how many of us, after being given the employment letter, would actually go back to see that? I mean, what you are looking out for is the remuneration, and once you see that, I've gotten this, then that is it. So many of us don't even know what the leave of a thing is about. You don't know how many hours you're supposed to spend working and all those things. So
even when they take advantage of you, you're not even aware that they're taking advantage of you.
That's just it. So you talk about termination, dismissal, and all those things. You don't know. Many of us don't even know that there are, things like that. Do you understand? So except you are this kind of person that, could be a bit curious and all those things, you definitely don't know most of these things, and that is why we're on this program today.
Yeah, to educate. I like that. I like the angle where this show is going. So now let's dive into it now, head on. So where are we starting from?
Well, we can start from anywhere.
Okay. So let's start with the contract of employment. What is that exactly?
Okay. In taking up employment by, the writings of the Labor Act, it allows you as an employer, to, now it could be, an employment can be either by oral. I mean, you can have an employment by oral understanding. Okay. But basically, it has to be a written contract of employment. Okay. By the Act, what you have is, you cannot be in any kind of employment without a formal written agreement or contract.
Are you kidding me?
Within 3 months, you must be given within 3 months of, taking up an employment. Okay. You understand? And that contract must state expressly all the terms of your employment.
Okay.
Yeah, you're talking about, your remuneration. You're talking about the kind of employment it is. You're talking about your job description and everything. You must know exactly what you're doing,
what you're getting into, so that in case there's any,
exactly,
you can say, oh, this is not right.
And a couple other things like that, that must be in your employment contract. That is what they call employment contract, because at the end of the day, if any issue arises, they go back to that,
to the employment
contract. What is not in your employment contract, if there will be any need, in court, what the court will look at would be what the labor law speaks about it. If the labor law is speaking something different from what is in your employment contract, definitely the employment contract would be null and void to the extent.
So it's not possible to take up it. So when you're I want to understand this. Yeah. So are you talking about this in terms of corporate businesses? Because I want to believe that a kiosk or a shop owner who just employs one boy to sell for him, is he supposed to give him a contract?
Absolutely. That's why I said most of all these things are, basically on paper. The shop owner, what does he know about employment contract? Okay. Do you understand? Someone that owns, is selling, what do you call it?
What do they know about?
What do they know about all these things? That they are menial workers, and the labor law itself is even more particular about them.
About the menial workers?
Of course. Oh. If you look at the definition of an employer, employee rather, by this law that we're examining today, it speaks more of, you as there is a better definition. Clerical workers and all those things. Then the second leg of it would be your administrative workers, the managers, the technical workers, and all those things. Now, those ones are not even, the labor law is not so much concerned about those ones, unlike
the ones who do the menial ones.
Exactly. Whoa. So the laborers and so on and so forth. So when it comes to being a manager and all those things, it leaves you to the contract that you are signing with your employer. But when it comes to, say, you are factory worker, all those kind of things, it is more particular about them than every other person.
Because I think it's because they're liable to.
Yeah, of course.
They're not being protected adequately.
They use you. Definitely they exploit you, and you don't. Most of those guys don't even know that this is what the law says. So they exploit them, extort them, and all those things, and then throw them out.
Exactly. Whoa. Okay. So now let's look at what is the right. What's the right law? What's that word to use now? What are the right things that are supposed to be in place in every, between the employer and the employee? What are the things that should be in the contract? And I like the fact that you said the people who do the menial jobs are the ones. So let's start with them. What should be, what are their rights as employees, and what should be in their contract, that justifies what they're doing, and that in the event of any kind of, accident, peril, and all of that they will be attended to.
Okay, just like Dapo stated, the first thing that every worker in that category must ensure is in their contract of employment is that they must have a contract of employment within 3 months of their being employed. Okay. So that's the first condition. We have so many. It must be written.
Okay.
We have several instances where you see individuals work for employers and they don't have contract of employment. Examples are banned, where all they have is, my employer says I should begin start work tomorrow.
Okay.
You ask them what the remuneration is, they tell you what are your job conditions. They don't know any other thing rather than the remuneration that come at the end of the month. So that is the first thing they have to know. The second thing they have to know in simple terms is the fact that the employer does not have right to pay their remuneration in any other way more than a month. So you can pay weekly, subject to the agreement with the employee. Okay. You can pay bi-monthly, but it must not be more than a month.
So you can't say I'll pay you 6 months.
So you can't except there's an agreement.
So there can be an agreement.
There can be an agreement, separate agreement.
Okay.
But ordinarily you should not pay more than 1 month interval.
Okay.
You understand? That's part of it. There is a provision that says that if you work for a continuous period of 12 months, you'll be entitled to a leave.
Okay.
Most employers don't honor. Employees don't honor. Certain circumstances, you even hear them say, you want to go for your leave? Maybe I should take somebody else. So while you're enjoying yourself at home, I would recruit another person to take your position. So because of the condition of employment in Nigeria, you see most employees work for years without going for leave. And even if they have to go for leave, they have to negotiate and start begging the employers to allow them go for leave.
A lot of times, they don't. For example, if it's 3 weeks, they can tell you can only take 1 week, and the 2 weeks is gone. But ideally,
the Labour Act makes it compulsory for employers to provide leave condition. Yeah. So there's another position that says that you're entitled to 12 days sick leave.
Okay.
In a year. So you're allowed to be sick. You're allowed to be sick, and then even if it goes beyond 12 days, the position of the law is that you must produce a medical certificate
to show that
really I've been bedridden for more than the 12-day period given. So those things are basic. Working hours, you're allowed to 1 hour break every day. It's compulsory. It's not negotiable. You understand?
But really, how is that possible? Like, for example, if you go to the banks, like when you have so many customers, their boss is even like, don't stand up from that seat, because there's like a long queue, and everybody's angry. So you can't. Let's finish with when you analyze this, then we move to the next level.
Okay, so those are just some of the basic conditions that is attached to employment, conditions of employment under the Labour Act. Okay. There are several other things. Termination, there's a position in the Labour Act, I think Section 11 of the Labour Act, that talks about the way manner of termination of employment. Either the employer and the employee can terminate the employment. You can't just terminate arbitrarily. There's a position for it. You understand? It if you've been employed for 3 months or less, then you can give your employer a 1-day notice of termination. Really? Yeah. It's a 1 day. That's the position of the Labour Act. Yes, for 3 months or less.
I thought they say it's 1 month.
No. 1 month is for people who have been employed for 2 years, between 2 years and 5. No, it's between 2 and 5.
Okay.
It's between 2 and 5. No, 1 month is for 5 years. I'm sorry. 1 month is for 5 years and above. Yeah. 2 years and below is for, I think, 2 weeks. 2
weeks.
Can you imagine now when people want to leave after 6 months, they're taking your salary, like you won't be paid.
No, it's very wrong. We've seen several instances where
they'll tell you that you won't be paid if you leave. Meanwhile, you've only worked for a very short time.
No, we've seen several instances where people have challenged this in court.
Are you serious?
Yeah, sure. That's why you should familiarize yourself with the National Industrial Court. They've delivered so many judgments in favor of the employees in this regard. So these things are sacrosanct. Except you have a contract of employment, as I said earlier, that says something different. If you put pen to paper and you agree to a certain condition, then that will be your burden to bear. But if there is no employment contract between the employer and employee, or the people we're talking about fall under the one categorized by the Labour Act, then these conditions are sine qua non. You can't do without them.
Yeah. Wow, that's deep. Awesome. So does this thing also relate to, do you want to say something? Do you want to add to what you have said? Okay, so this, now we talked about the people who, so does this also relate to the people who work normal 9 to 5?
Definitely.
Okay. So what's the normal work hour for a person in a normal corporate environment?
Just like we said, there can be a contract of employment that says otherwise.
No, but so if they say otherwise, and this is what the law says, aren't they supposed to be obeying the law?
No, I think you're getting it wrong.
Because
this is the way it works. The Labour Act does not cover every aspect of the relationship between an employer and an employee. It covers some basic aspects, at least for now. It covers some basic aspects. The basic aspects they cover refer to people who are referred to as workers. Workers are clerical staffs and some other people that you understand, laborers. Now, for technical staffs, technical can be a professional, just like a lawyer, a doctor, and all those other people. People in that category, they have their own contract of employment, which they sign with the employer. You understand? So whatever is contained in your contract of employment is the guiding agreement between you and employer.
So the labor law doesn't tell the employer how to enter into a contract with you. It only stipulates a couple of things that must be constant. For example, your work hours, your leave, remuneration. So any other thing in the contract is between you and the employer. So it's you as an employee to actually look at your employment contract, be okay with what is in there, then you agree.
And ensure that it's not
going against
the provisions of the Labour Act.
Against the provisions of the Labour Act.
So you spoke about the time. Like how many hours you're expected to spend, maybe all those things. Even the Labour Act itself, it makes it open to the extent that you can have a mutual agreement with your employer. That is one. You can look at the practice in the industry. Just like yours now, you are in a radio station like this, and
you always have to be.
You probably always have to be around, and all. So you look at the industry practice. Do they allow you to stay overnight? Do they? So they make necessary provisions for you and all those things. Then you look at it as there could be several ways to it anyway. But by the act, it allows you to negotiate all these things. But the only thing is that when you are working beyond, you are stretching yourself for a period of time. Let's say, for instance, you've been at work sitting by your desk for about 6 hours. There should be a break time. You understand? There must be, a time for you to flex your muscles
at least, relax a bit,
and all those things. That's allowed as well. Then you look at it, and if you are doing more than the agreed time, your employer is expected to pay you what they call overtime, which is very, very important as well. Yeah, it's by law you are entitled to it.
But does Nigeria, do they pay anybody overtime?
Okay. I was
because a lot of people actually work overtime, but they don't get paid.
In my foray, at least so far, I spent about 4 years as the head of HR and admin in a company.
In a company, okay.
And sometimes when I even call that, let's compute your overtime and all, some of my employees will still tell me, Oga, no worry, it's not compulsory, Daddy. I don't do it for God,
Okay,
you understand? Some people want to show so that
the company won't say that you want overtime.
Some people, it's not out of ignorance. Some like we were talking about leave the other time. Some people don't want to go home. Exactly.
They don't need to go and rest.
It's more like.
But at least let the company even say, go first. Then let the person say, I don't want to go.
Some companies will tell you. Some HR will tell, come on, you've not
gone on your leave. Okay.
Okay, I get plenty work. I didn't know. You have to go. Some people will still say, okay, fine. They'll take the work home. I'll just. I mean, we have different people in this country.
Yes,
that's why
true.
even while we were in school, you want to read 24 hours. When exam is approaching, you want to read. All time. So the school will say, okay, fine. The light that has never been epileptic, that is the time the light will now become epileptic. Because some people still want to run mad reading and doing all those things. Some people just want to walk. They want to leave the house.
Because some of them think like, okay, if I'm just at home and I don't go to what will I be doing? So let me just
Then the condition of things in this country itself is something else. Okay. So what I would just advise people is to familiarize themselves with all these things, and then do a bit of research will never hurt. Okay. We do a lot of things on social media these days. Do a bit of research
to know what is meant to be and not. Okay. So in case you fall into a situation, because our time is already, we have just about 5 minutes to go. Oh, wow. But just in case somebody is, you have this kind of problem at your workplace, what do you do?
What type of problem?
For example, if you're going against your employer is going against the stipulated contract that you guys have. For example, your employer says you can't go on leave, but I want to go on leave because I'm entitled to leave, and he says you can't. Or probably I want to leave. No, if you leave, you're not going to get your salary for 1 month. But ideally, the law says that if I have worked for 2 months, I can give you 1 day's notice. So when that happens to an individual, an employee, what do they do? Who can,
Yeah.
Okay. I stand to be corrected, but most contracts of employment nowadays do have this clause in the contract of employment that says that any dispute arising from this agreement shall be referred to a mediator or an arbitrator. Such will not be referred to a court of law. Now,
so they've removed their hands.
No. You can't foreclose employees from seeking judicial redress.
Okay.
You understand? But what we're trying to say is that most employers want to protect the image of the company. So most times they want you to negotiate, they want to discuss with the HR and see ways where you can
resolve it amicably.
But if you can't resolve amicably, that is when you approach the court. The National Industrial Court has exclusive and original jurisdiction over employment matters between employer and employee. So, like I stated at the beginning of this program, we have several cases at the National Industrial Court that are pending, some that have been won, and several others.
So can you cite a few examples or not?
Few examples of the cases?
Yes. Okay, before we even go there to the examples, we don't have time anymore, but what about workplace harassment? I was going to go to that. Like, is that part of the Labour Act? Is there anything that talks about that in the Labour?
Apart from the Labour Act, the Constitution of the Federal Republic of Nigeria talks about discrimination. If there's discrimination at the workplace on the basis of sex, age, ethnicity, and some other things, disability, even your HIV status, you can challenge such position in court. So if you are being discriminated at your workplace, an employee can seek judicial redress.
Wow.
Okay, let me take it further. I believe what you're asking is maybe in terms of maybe sexual harassment.
Yes, harassment
and all those things.
yes.
Yeah. If you look at the law holistically, it may not necessarily, give you
that particular
answers to all those things. But you look at it, most employers these days, they have what they call employee handbook. It serves as a guide for any kind of dispute arising from this. I mean, that's why you see most companies these days, they don't play with anything that has to do with HR.
With HR, okay.
So HR would have to develop such a thing in such a way that whenever issues like that arises, you know the levels to approach.
Okay.
But when it becomes something that is criminal, when it's a criminal thing, it goes beyond just talking about it. It goes beyond the office thing.
Yes.
Do you understand? That way you can take it up and then make it the state issue. So it will become the state and whoever is harassing you.
Okay.
So for whatever it's worth, we've got a lot of such things happening and going on.
Okay.
But why would people not want to speak out about it? They don't want to lose their job.
Yeah, no, but maybe it's because they feel as if there's no law that is backing them up.
Even if there's
so they feel like we're helpless. So even if we talk, nothing will be done. You understand?
Even if there is law that is backing it, why would people not want to speak out? Because my MD is harassing me. If my MD is harassing me and I take him to court or I bring it on social media, who will give me food? Who will give me another job?
Yeah.
Do you understand? You look, the economy in this country
is
something else. So you just want to manage. I've had instances like that even I myself as a lawyer would advise, if you are not ready to leave that place, avoid contact.
Wow.
Do you understand? Like, because if you, the basic thing is be ready to leave. Then if you are ready to leave, then we can now do something. But if you are not ready to leave, do you understand? You just find a way to avoid
away from the person.
Exactly. So when it comes to office harassment, there's a lot of that. But when it comes to maybe colleague to colleague, you can take that out. Okay. When it comes to colleague to maybe
a higher authority,
an higher authority, you can
superior.
Still take it up.
Okay.
But when it comes to, and it happens, talk to many lawyers today that are females. Female lawyers.
They will take up that.
No. Okay. I'm telling you, female lawyers that are being harassed.
Wow.
Of course, lawyers.
So you can imagine they are the law.
So, lawyers that knows all these things we're talking about, that works in law firms.
Whoa.
Do you understand? That are being sexually harassed. But they can't say it now. It's not as if those guys are bigger than them or anything, but these things have it's
the economic situation. Like, exactly. What do we do when we live here?
Exactly.
Where do we go?
So that's just the whole issue. So when that's why I keep saying we have the law. Most of all these things that we're going through in this country are actually being written somewhere. But the whole truth is, how many of us are even ready to go look for it? How many of us, in fact, going through, is there protection for you? Do you understand? Is there maybe a cushion where you land after the whole this thing? Nothing. So if you do it, you fight for some other people, it's fine.
Wow.
Some other persons will be there laughing at you. So you go hungry on your own.
You're your own, that's true. Okay, so finally, before we just, round up, I want to talk about people who do menial jobs where they have to carry things, stay in, some of them, they're supposed to give them some kind of, like, for example, you should be wearing a helmet. If you're going to be dealing with machinery, you should have something so that you don't cut off your hand. What do you do? Because I know there are a lot of companies, even I think sometimes the police always find some factories where they have staff working there and they don't have the required things. Is there anything in the law that talks about that? And who comes to their defense at the end of the day? Because I know somebody who cut his hand off, someone in Ogun State in a factory, and they were not willing to do anything. I think they gave him 10,000 naira, like, just go and treat yourself. And they even sacked him. Like, don't come back. I knew somebody who was working there, was his colleague. So his hand, because I believe if he had the right, something wasn't done right for him to have lost. Do you understand? So is there a law, that does something about that?
Yeah, there are laws. I mean, in fact, the Labour Act itself, is one of those that champions, causes like that.
Okay.
First, in fact, these are things like what you said now. There are task forces. There's more or less like a body of, the government that is saddled with the responsibility of going through and checking for all these things in those companies. Okay. So
It's safety to check that the safety everything procedures are in place.
You have that. Then beyond that, you have trade unions.
Okay.
Do you understand? You have trade unions. Oh, okay. You have trade unions that actually work on that as well. And then there are so many things that we can't exhaust it.
Exactly.
We can't exhaust it now. But seriously, it's just so sad for someone like that.
That he just.
Beyond that, there's what they call. There are certain insurance policies that every company
should even have for their staff.
If I'm not, you should. It's a must.
Is it compulsory?
Yeah, that go through the employee. We call it the Employee Compensation Act.
Okay.
It's a law that talks about all these things. So this person that they gave 10,000 naira, if he wants to challenge it, he can take it up and then he will get more than that.
But illiterates, they don't know what to do. Okay, it's always a great time having you guys in the studio, sharing knowledge. Like, I always learn something new when these wonderful people are here. So thank you so much for being on the show. We've already exhausted, the required time. Yeah, but I learned a lot, and I'm sure you guys learned a couple of things too. So till we do this again, it's Business Law on Insights Radio. And my name, of course, is Kewe Akindola. Till I come your way same time next week, do have a great day.
Thank you.